3, 2, 1.
Okay guys, this is an episode of Scott Talks Law, and welcome once again to another episode of Scott Talks Law. So in this episode, we shall be talking about plea under criminal procedure and practice. So plea is that response by an accused person to allegations in the charge sheet. An accused person pleads either guilty or not guilty to the offenses in the charge sheet. So a charge sheet shall be presented to the accused person, and this accused person must be informed of the offenses in a manner in which he or she understands well before he pleads those allegations, either guilty or not guilty. An accused person can also enter into a plea agreement with the prosecuting side in order to reduce the offenses or the charges in the charge sheet. So these two parties can enter into a plea agreement or negotiation which does not involve the court. It independently involves those two parties or two sides, the prosecuting side and the defense side, to reduce some charges or to drop or withdraw some charges in the charge sheet. So these two sides can enter into a plea agreement or a plea negotiation that does not involve the court. So you have a plea of guilty and that plea of not guilty. A plea of guilty is whereby the accused person admits the charges in the charge sheet, and that of not guilty is whereby the accused does not admit to the charges. So we also have persons of unsound mind, and these persons of unsound mind, before they plead, they must first be presented to a psychiatrist who will test their state to ensure that they are able to plead to the allegations and they can understand before they plead to the allegations in the charge sheet. If they cannot plead, they are not in condition of sound mind to plead to those allegations, then they shall not plead to the charge sheet. And we also have those big offenses. We have offenses like that of death sentence. And before this, they plead to these offenses, the accused person must first be informed in a manner that they can understand, and they can be given some time to go and think before pleading either guilty to that offense. So you also have a plea of out of voice convict and out of voice acquit, that a person shall not be convicted twice for an offense that he has already been served or acquitted. So in a court of competent jurisdiction. So out of voice convict and out of voice convict is also another plea that a person shall not be plead to a charge that he has already served. So once informed the information in the charge sheet, the accused person is called upon to plead to the information either guilty or not guilty according to section 207 and 274 of the CPC Criminal Procedure Code. So in the case of Adam versus Republic 1973 and John Mwenda Mosau versus Republic, it's a total omission not to explain to the accused person the elements of a charge. An accused person must be told of the elements of a charge. If not, that is an omission. So particular attention should be paid to accused persons who are not represented, and the court should ensure that a charge and all the elements of the offenses are thoroughly explained to the unrepresented person. There are those persons who are not represented. Those elements must be explained well to this person so that they can understand before entering into a plea of either guilty or not guilty. The court must ensure that the prosecution furnishes the accused person the charge sheet or information. The particulars in the charge sheet or information must be sufficient to enable and prepare the defense. So the prosecuting side, the court must ensure that the accused person is presented as the charge sheet, and the particulars contained in the charge sheet must be in a language that the accused person understands. No technical language should be used, so that the accused person or the defense side is able to prepare for a sufficient defense against the prosecuting side. So where there is more than one accused person, each person must be addressed individually, and individual response is recorded as nearly possible in their own words. We have cases whereby we can have more than one accused person. You can have like 3 accused persons. So each accused person should be addressed individually, and each individual response should be recorded according to how they responded to the information in the charge sheet, according to the case of Bayer versus Republic. So in the case of Bayer versus Republic, the accused must be personally plead to the charges. He must personally plead to the charges. So Johnson, Kasim, Mwandi, and another versus Republic. A corporate entity can also be charged with a criminal offense. A corporate entity can also be charged with a criminal offense, and this corporate entity also can plead to the charges. As it was said, in the case of Mumia Sugar Company Limited, WSM Dambo versus Republic, the High Court of Kenya at Kakamega Criminal Appeal number 11 of 2008, the court must satisfy itself that the person taking the plea is authorized to do so on behalf of the corporate entity. So we are, like, our manager can represent that corporate entity and go and take that plea. So you must be authorized to do so, to take that plea on behalf of that entity. So official of a corporate entity must also be charged in their own personal capacity for offenses attributed to the company based on their position in the corporation or that conduct. So if you are an official to a company and you do an offense, you can be charged individually as you can be charged personally in your own personal capacity to the offenses, and you can plead either guilty or not guilty to the particular charge or offense. So procedure for taking a plea: after being read the charges, accused person must admit or deny to the charges. An accused may also opt to remain silent, in which case a plea of not guilty is entered as discussed below. So if you remain silent, a plea of not guilty is entered. So let's look at the plea of guilty. When accused person admits to the charges and the particulars of the offenses, a plea of guilty should be entered. The procedure to be followed where an accused elects to plead guilty in subordinate court is set out in section 207 subsection 2 of the penal CPC. So if the accused person admits the charge, the court must record the admission nearly as possible in the words used by the accused person and then formally enter a plea of guilty. So the court must admit the admissions in the words, exact words used by the accused person according to section 207 subsection 2 of the CPC in the case of Adam versus Republic. So the aim to enter is to ensure that the plea of guilty is unequivocal and that the plea as recorded cannot be interpreted in any way other than the as admissions of guilty. So this is to ensure that the plea is unequivocal. No other interpretation apart from that which was the words which were used by the person who admits to that charges can be no other interpretations can be interpreted. So the exact words should be recorded. So when the accused person is unrepresented, the duty of the court to ensure that a plea of guilty is unequivocal and is hastened as emphasized. So in Farahat Ibrahim Ahmed and two others versus Republic, High Court at Kisumu, Criminal Appeal number 68 of 2016, the court held that the danger of a conviction on an equivocal plea is obviously grievous where the accused is unrepresented. The limit is limited education and does not speak the language of the court. So the danger of a conviction of an on an equivocal plea is obviously grievous where the accused person is unrepresented and the limited education and does not speak the language of the court. So the accused person plea must be specific and not merely general assertion of guilt. It must be specific. The record of plea must be specific, not just mere general assertion of guilt. You must be specific if you're pleading guilty. So in the case of Kariti versus Republic, the trial court read as follows: accused 1 story is correct, accused 2 story do, accused 3 do, accused 4 do. The court plea of guilty entered for all. Like, it wasn't certain. So the accused 1 says that to do, correct. Someone is just saying correct, I do, yes. So presumably do or did to. The appeal court held that the court had failed to follow the procedure for recording a guilty plea as set out in section 207 subsection 2 of the CPC and in the case of Adan versus Republic. So it's also noted that the use of words do by the trial court did not show admission or facts and therefore ordered a retrial. So if you just say do, I do, yes. So those words does not indicate a clear admission to the offenses in the charge sheet. So the court erred in recording that plea because those words did not indicate a clear admission to the charges in the charge sheet. So when an accused person is charged with more than one count, the court should record the plea in each count separately, as they were said in the case of Bena versus Republic. So if you plead to more than one counts, the court should record the admissions in all counts. So if there are 12 counts, all the admissions in the 12 counts must be recorded by the court. The Court of Appeal at Kisumu Appeal number 36 of 1981, the court must be satisfied that the accused person wishes to admit without any qualifications each and every element of the offense charged. So the accused must be satisfied that the accused person wishes to admit without any qualification each and every of elements of the offense charged. So the court must be satisfied that the accused person wishes to admit to the charges. So a court have held that for the accused person to say it is true or not true necessary to a plea of guilty if it appears that the accused disputes some elements of the offenses. Once the accused person admits the charges, the prosecutor is required to state the facts upon which the charges is based. In the case of Adam versus, it's not enough for the prosecution to state the facts as per the charge sheet. The statement of facts must be explained to the accused in a language that he understands. So the accused person, the prosecuting side does not just explain the facts as per the charge sheet, but goes further, supposed to explain it in a manner that the accused person is able to understand, expound on that information, the prosecuting side, so that the accused person can understand, or in a language that he understands well, so that he can plead either guilty or not guilty. So this implies not just a language with the accused person aside, but also the use of ordinary words. Technical words should be avoided. Avoid technical words that will confuse the accused person. So the accused must admit the facts as stated for the court to satisfy itself that a plea is unequivocal. Admit those facts. So in Obedi Kilonzo Kivevo versus Republic, court held that the statement of facts did not disclose an offense because it did not indicate the age of the victim in a defilement case. So the plea of guilty was therefore not unequivocal. So the statement did not disclose the offense because they didn't indicate the age of the victim. So the statement of facts must indicate clear information about the information in the charge sheet that the accused can plead. So the plea of guilty was not unequivocal. The plea of guilty is supposed to be unequivocal. So if the statements are not explained well, then it is not unequivocal. So in the case of Bedi Kivevo in Obena versus Republic, the Court of Appeal at Kisumu Kuma Appeal number 36 of 1981, the appellate court was not satisfied that the plea was unequivocal because the prosecutor had simply indicated that the facts were as per the charge sheet. So the court must ensure that the accused understands the substance of the charge. Accused must understand the substance of the elements of the charge. So when the accused person facing a charge punishable by death wishes to plead guilty, the court ought to explain the penalty attracted to the offense, and in such a case it's good practice to adjourn the hearing and allow the accused person to reflect on the plea before proceeding to convict. So the court must make sure that the accused person understands the penalty associated with that offense of death penalty, and the court can also adjourn that proceeding to ensure that this accused person goes to reflect to that admission, whether he is going to admit guilty or not guilty before admitting. So it's a good practice to adjourn the hearing and allow the accused person to reflect before proceeding to convict. So in Duandete David Munyoki versus Republic, Court of Appeal at Malindi Criminal Appeal number 56 of 2013, the court must be convinced beyond reasonable doubt that the intention of accused to plead guilty. So the court must be explained beyond reasonable doubt that the accused person really intended to plead guilty to that offense. Upon hearing the facts of which the charge is placed, accused should be given an opportunity to respond to the facts. If accused denies the facts or offenses, offers an explanation that amounts to a denial, a plea of not guilty should be entered according to section 207 subsection 3 of the CPC. So if the facts are admitted, the court must convict the accused person or plea of guilty. So if the facts are admitted, the accused admits, then should be convicted and a plea of guilty has been entered. So the plea of not guilty, and whereby the accused denies the allegation of the charge. The plea of not guilty is entered in the following instances. The accused does not admit the charges according to section 207 subsection 3 of the CPC, or the accused does not admit the statement of facts. In the case of Adan versus Republic, don't admit the statement of facts, and the accused refuses to plead. If you don't plead at all, then a plea of not guilty is entered or is supposed to be entered. So let's look at the plea bargain. And plea bargain is that negotiation between the accused person and the defense, accused person on the defending side. So after the accused person has been charged or at any time before judgment, the prosecuting and the accused person may negotiate and enter into an agreement for the reduction of the charge to a lesser offense, for the withdrawal of the charge and a stay of other charges, for a promise not to proceed with other possible charges. So you can enter a negotiation to withdraw some charges, to proceed with other possible charges and not to proceed with others, and to enter agreement for the reduction of charges to a lesser offense if it's a big offense. So you have those charges, that other offenses that cannot be entered into a negotiation, like offenses described by the Sexual Offences Act and those against murder, genocide, and so the review of the victim must be sought in any plea bargain. The view of the victim must be sought in any plea bargain. A victim's view, what is your... So according to section 37D of the CPC and 591C, Victim Protection of the Victim Protection Act. So the plea agreement may provide for the payment of an accused person any restitution or compensation. So if the prosecution undertakes the privately and is undertaken privately, a plea agreement may provide for the payment of an accused any restitution or compensation. If the prosecution is undertaken privately, a plea agreement can only be entered with the consent of the DPP. So if a plea agreement is entered privately, then with the consent of the DPP, that agreement can be entered if it's a private plea. So a plea agreement may not be used in relation to prosecution under sexual offenses, offenses of genocide, war crimes, and crimes against humanity. A plea agreement cannot be entered into those offenses because those are big offenses that we won't allow plea agreements negotiations. So the court should not interfere with the prosecution's discretion to engage into a plea negotiation. However, where the prosecution is in a breach of obligation under Article 157(1) of the Constitution, party may apply to the High Court of appropriate order. So where there is a breach by the prosecution side, breach Article 157 in that plea Constitution, that plea negotiation, then appeal to the High Court can be the appeal. But the court is not supposed to interfere. This it's about those two parties, but not court. The court is not supposed to interfere. In the case of Mary Kinga Rukwaru versus Office of the DPP and another versus High Court and Kenya Nairobi petition number 2526, the court does not participate in plea negotiations. The plea agreement must be in writing and must adhere to the requirements set out in the section 137E of the CPC. The plea agreements must be in writing. The court must not interfere with those negotiations. The Office of the DPP has developed rules on plea agreement pursuant to section 137 of the CPC, which mandates the DPP to make rules relating to plea negotiations and agreement before entering into a plea agreement. The court is required to place the accused person under oath. So the DPP sets out the rules that are to be used to govern the plea negotiation. And before entering into a plea, the court is required to place an accused person under oath and personally address him or her. The court must inform the accused person and ensure that the accused understands the right pertaining to that trial and implication of the plea agreement. So accused must understand. The court must also be satisfied that at that time of entering into a plea agreement, the accused was competent and of sound mind and acted voluntarily. He was not coerced or forced to enter into that agreement. It was of sound mind and understood the terms of the negotiation according to section 137G of the CPC. So when a court accepts a plea agreement, it must record a factual basis, that is, the facts informing the plea. So the court accepts, when a court accepts a plea, we must record the factual basis, that is, the facts informing the plea. So if the court accepts those agreements, then it must record the factual basis, the facts informing the plea according to section 137(1) of the CA of the CPC. The facts that the accused person admits must be recorded in order to ensure that they support the offense. Agreement becomes binding on the parties and form part of the court record. So this agreement becomes binding to those parties. Then the first part of the court record is that the court will or shall record. Alvin Kamande, Njenga, and another versus Republic, where an agreement involves the reduction of a charge to a lesser included offense, the court must, upon accepting the plea agreement, convict the accused on that lesser offense according to section 137H2 of the CPC. So if that plea agreement involves reduction of offense to a lesser offense, then the accused must be convicted to that less offense that was pleaded in that plea agreement. So when an accused Where the court rejects a plea agreement, must record the reasons for the rejection and inform the parties. Plea agreement then become null and void. So if court rejects, then it must give satisfactory reason as to why the court rejected, then the agreement will become null and void. Proceeding given to it becomes inadmissible in a subsequent trial or any future trial relating to the same fact. So those proceedings cannot be presented in another trial that were declared null and void. So a plea agreement has been rejected and the plea is not guilty, consequently entered, the prosecutor must institute a fresh proceeding before another court unless the accused waives the right to have the trial proceed to another court. So when the plea of not guilty is entered, the prosecutor must institute a fresh proceeding before another judge unless the accused waives that right to have the trial proceed to another court. If a plea agreement has been rejected, there can be no further plea agreement negotiation in relation to the same facts, and further no party can appeal or apply for a review of an order rejecting the plea agreement. So if it has been rejected, then that's it, null and void. An accused may withdraw a plea of guilty resulting from a plea agreement from any reason before the court accepts the plea. So accused may also withdraw a plea of guilty resulting from a plea agreement. So if he had pleaded guilty in that agreement, he can also change his mind and then may withdraw a plea of guilty resulting from he can withdraw. So any reason by the court accepted. So the accused may also withdraw a plea of guilty after the court has accepted the plea agreement and entered a conviction before sentencing. This instance, the accused person must provide. So the plea agreement is not final. An accused person can also withdraw the plea of guilty if he had pleaded in that plea agreement. So accused person can also change the plea to not guilty. So a sentence passed by court following the plea agreement is final. No appeal lies in the exempt. So if a sentence is passed, then that plea agreement is final. So a sentence passed by a court following the plea agreement is final and no appeal lies in it except to the extent of legality and sentence imposed in the David Irongo versus Murithi versus Republic. David Irongo versus Murithi versus Republic. After the sentence, then it is final. However, conviction on a sentence obtained pursuant to the plea agreement can be set aside on counts of fraud or misrepresentation. So the exemptions here are only fraud and misrepresentation if a sentence has already been passed. But if a sentence has already been passed after the plea agreement, then that sentence is final. So let's look at the plea of persons of unsound mind. So all persons are presumed to be of sound mind until the contrary is proven, according to section 11 of the penal code. And where a person of unsound mind is charged, the court should proceed as follows. The court must determine whether the accused of sound mind by referring him to a psychiatrist. Thereafter, if the court certifies the accused person is of sound mind, then the court must require the person to take plea. So the person must be referred first to the psychiatrist before taking plea. The court finds that the accused person to be of unsound mind and constantly capable of understanding the following proceedings. The court should proceed as follows. According to section 162 and 281 of the CPC, postpone the trial. If he is on unsound mind, then the trial shall be postponed. Order either that the accused person to be held in custody in a location where he is safe and will not be in danger of himself or others, or that he is accused, so that the accused be released on bail. So he should be held in a safe custody and can also be released in bail if he is of unsound mind. So if the person is held in a safe custody, repose the case for the order of the president. So when making an order for an accused person to be held in safe custody, the court should bear in mind the need to protect the accused person and other persons. When an accused person subsequently becomes capable of making his defense, the medical officer must forward the certificate so that the effect of the Department of the Public Prosecution. So the psychiatrist offers the certificate of this accused person to ensure that to confirm that he's of sound mind and is able to plead to those allegations in the charge sheet. So the plea of out of voice acquit and out of voice convict, the plea on double jeopardy. So a person shall not be tried for an offense in respect to an act or omission for which he or she has previously been acquitted or convicted by a competent court. Shall not be convicted or acquitted for an offense which have already been acquitted or convicted by a competent court. The court should be competent. So the Nicholas Kipsigei, Ngetich, and the 6 others versus Republic. However, a person may subsequently be tried for an offense that he or she could have been charged with in former trial section under section 135 for the CPC. An accused person may also be charged with respect to an act whose consequences had not occurred or were not known at the time of the previous trial of the CPC, according to the provision of section 140 of the CPC. The plea of auto-voice acquit or convict does not apply where the accused person was tried by a court that was not competent. The court must be competent. So if the accused pleads that he or she has previously been convicted or acquitted of the same offense under the court is required to try that plea. If the plea of a previous conviction or acquittal is not established, the accused is required to plead to the charge. So if it's not established that he was acquitted or convicted in that previously, then he's supposed to plead to this present charge. The court should record that plea in that charge. So the previous conviction should be proven through a satisfied record to the court. A certified record should inform the court of previous conviction. A certificate signed by the officer in charge of the prison in which the accused person has been detained, or a warrant of commitment to the prison. So the accused person must present these certificates or signed by the police in charge in that particular prison where you are imprisoned. So you must show the proof that you are charged earlier before this present charge. So a change of plea. The plea can also be changed. An accused person may change a plea of guilty to that of not guilty at any time before a sentence is imposed, and this change must happen before the sentence is imposed. In the case of John Mwendo Masau versus Republic, accused may also plea a plea of not guilty to that plea of guilty. You can also change to not guilty to guilty. You can change a plea of not guilty to guilty and a plea of guilty to not guilty. So the case of Boniface Kioko versus Republic, the court should be careful to ensure that the accused understand the decision to change the plea. So the plea, as far as the court would, the court must be careful to ensure that the accused person understands the nature of the plea before changing the plea not guilty to the plea of guilty. So guys, just a review of what we've learned. So we have been learning about plea under criminal procedure and practice, and we've seen that a plea is that admission or rejection of the accused person to the charges or allegations in the charge sheet. A plea can be guilty or not guilty, and a plea of guilty is whereby the accused person admits the offenses in the charge sheet, and a plea of not guilty is where he denies the offenses in the charge sheet. There can also be a plea bargain where there is a negotiation between the accused and the prosecuting side to reduce the charge, to withdraw some charges in the offenses in the charge sheet, or to proceed with some and drop others in the charge sheet. So the plea agreement negotiation does not involve the court. It's independent of the court. It does only involves the parties who are entering into these negotiations, and the court should record the plea agreement, and the accused person can also change if he had pleaded guilty to the plea agreement to not guilty before the sentence is imposed. So there can also be a change of plea. So we also looked at the plea of persons of unsound mind, and these persons must be presented before a psychiatrist before they plead to the allegations in the charge sheet. They must first be presented to a psychiatrist to test whether they are competent to plead to the allegations in the charge sheet. If not, then they can be put in custody, and they can also be released in bail. So you have also looked at the plea of auto-voice convict and auto-voice acquit, that no person shall be convicted twice for offenses under double jeopardy. So we have looked at it, double jeopardy. And we also looked at change of plea, that where a person can also change a plea to a plea of not guilty to a plea of guilty, or a plea of guilty to a plea of not guilty before the sentence is imposed. So we have looked at the plea bargain, change of plea, and the procedure for taking a plea, where the accused person admits the allegations in the charge sheet, the procedure of taking a plea of guilty, and the plea of not guilty. So guys, I think that is the end of my lecture on plea. And just have a nice day, and subscribe to Scott's Legal channel. Comment on the comment section about the episodes and the lectures, and have a nice day.